I continue with my work as an appellate lawyer, pretty much, and that's what I did when I was in the public defender's office as well. I've been doing it for 25 years, and I happened upon a client about, I don't know, a year and a half ago, who came to me about the registry, and at the time I knew nothing about the registry. But I was so appalled at what he was telling me his life was like. And it's not that I didn't believe him at first, but I was sort of like, really? Is this really what's happening? And then somehow my name started to get out there, and, more and more folks were coming in to me, and I'm speechless at the things I've learned about the lives that folks have to live on this registry. And I know that Brenda said earlier, we're not here to vent or anything like that, but that's for you all. I'm venting. I'm a lawyer. I've been a lawyer for a long time, and I am just astonished that people think this is a good thing. I mean, at the lengths that it's gone, that they think it's a good thing. And I'm telling you, I can't emphasize enough what Brenda had said earlier about going down and speaking to your legislators. Even if you're uncomfortable about actually testifying, you can get a meeting with your legislator in his or her office and sit there face to face and tell him or her what your life is like, what your family's life is like, because I guarantee you they have no idea. They have absolutely no clue the effect of their laws. It's just that, beat your chest and say, I'm tough on crime, and, I can get reelected that way. That's what it's all about. But when you're face to face with them, it does make a difference. They have to know what the effect is of these laws. And as an example, when Brenda was talking about the kidnapping, I had a client come to me who, was convicted 20 years ago of kidnapping that had absolutely nothing to do with a sex offense or a minor, and it was all related to drugs. And he said, I got a call. He's been out of jail now for 6 years. He said, I got a call, 4 years out of jail, and they said, I have to register for life as a sex offender. And I said, well, what's your conviction? And he told me, and, I have to say I was a little skeptical that there must have been something that had to do with a sex offense. And so I ordered his transcript of his trial from 20 years ago. And sure enough, absolutely nothing to do with any sex offense or a minor. So I called Senator Mike Miller, and I said to him, do you realize that this is on the registry as an offense? He said, no, it's not. And I said, no, Senator Miller, it is on the registry. And he said, well, let me have you talk to my staff. So I talked to a staff lawyer, again, had no clue. So I said, let me fax all this to you. So I faxed it to them. They called me back and said, we had no idea that this was even on there. But he voted for the bill that put it in. And so then I called Chairman Valerio, Joe Valerio, who's very powerful man, and told him. And so he has introduced a bill on the House side. Senator Miller has introduced it on the Senate side. I'm hopeful that it'll pass, and I'll be testifying. But my point in telling you all this is simply that unless it's in their face, the effect of a bill or how it's changing your lives, they are totally uninformed about what's going on out in the community when they pass these laws. So make your voice heard. Let them know, even if it's in writing, by telephone, personal meeting, or testifying. And if you can get your family members to do it as well, to tell them the effect on you, that's very powerful, okay? Because really, there are only two ways these laws are going to change. One is through the legislature, which is not as likely, but the other is through the courts, okay? Now, in the courts, this is where, and I think my name is on a wall somewhere because people just keep calling me now and writing to me and meeting with me about these laws. Can I represent them? And I'm very upfront with everybody. I say, look, I have two cases now, one in the Court of Appeals, which is Maryland's highest court, and one in the lower level appellate court. Save your money, don't pay me, don't pay a lawyer, because if I win on these cases, it will affect everybody. So sit on your money for a little while, and if it doesn't work out in these cases, then come back to me and I'll take your money then. And that's just the public defender in me. I'm not used to taking money for things. So let me tell you a little bit about the cases. The one is in the Court of Special Appeals, and I will be arguing that I think it's in May. It's either April or May, but in any event, the issues in that case, I worked with the trial lawyer, and it's out of Wicomico County. I worked with the trial lawyer at the time that he was doing it to make sure that all of the issues were properly raised, because the way it works in the law is if the issue is not properly raised at the trial level, I can't do anything about it on appeal, okay? So I made certain that it was every issue that I want up in the court is there. And so this case, and it's called John Roe, all of them are pseudonyms, but this case involves these issues. Number one is the ex post facto argument, challenging the constitutionality of the retroactivity portion. The 2010 law that went into effect on October 1, 2010, that made everything retroactive and swept up everybody and their brother into the registry. Now, I know that there are Supreme Court cases that have said that the ex post facto laws do not apply to registry laws because it's not punitive. All right, everybody laugh. It's not punitive, which is another outrageous thing that they keep telling me. It's regulatory, it's administrative. It has nothing to do with punishing people. But there is the federal Constitution, which prevents, or prohibits, I should say, ex post facto laws, which means, for all the non-lawyers out there, that Congress at the federal level and the legislature at the state level cannot write a law that goes backwards and makes something a crime that was never a crime at the time it was committed, or cannot write a law that makes punishment worse than it would have been at the time the crime was committed. And that's really what these registry laws are. They're ex post facto because they make, obviously, your lives much more miserable than they would have been at the time the crime had been committed had it not been for this retroactive law. So at the federal level, the ex post facto constitutional provision has always been turned down, as in just about every case I'm aware of. When it's applied to the registry, they say, no, ex post facto doesn't apply to this kind of case. Well, I came upon the Maryland Constitution. I decided we can't get anywhere with the feds. So I'm going to look at Maryland's Constitution, because every state has its own Constitution. Maryland has an ex post facto provision in its Constitution that has two clauses. And if I'm getting too technical, just tell me to shut up. But it has two clauses. One says the legislature shall pass no ex post facto punishment, okay, which is identical to the feds, so we know we're not going to get anywhere on that, okay? But then there's a second clause that said, nor shall the legislature pass any retrospective or retroactive restrictions. Now, it seems to me that if the response by the courts and the prosecutors and the attorneys general is always ex post facto only applies to punishment, and the registry is not a punishment, so therefore you can't use it. All right, fine. What about the clause that says it applies to restrictions? which is something less than punishment, and which is what you all live your lives by now, are tons of restrictions in the registry. So that is the issue, to me, is the most promising issue. And it is not only in the case in the Court of Special Appeals that I'll be arguing in a couple months, it is also in the petition that I have filed with Maryland's highest court, the Court of Appeals. What I sent out around is the single sheet of a portion of the petition that I filed with that court, saying why they should hear this case, because they pick and choose the cases. And I think you can see that I vented a bit in that, reasons for taking this case, because I feel so strongly about it. And my hope is that the Court of Appeals will take this case, and I will know within the next 3 weeks whether or not they take it. Now, I think they will. I can't guarantee it, obviously, but I think they will, and here's why. I also happened to be in the Court of Appeals back in, I don't know, like 6 months or so ago, arguing a case on behalf of a client who was made to register, and he was a real estate broker, and the real estate board then wanted to take his license away because he would be showing houses to people who would bring children. Anyhow, while I was up there arguing that this shouldn't be done to this man, the court, several of the judges, 2 of them, of whom I know personally and from work, are very conservative judges. They were outraged. And when the state got up to make its argument and said, the registry isn't punishment, you know, the typical line, this one judge in particular said, let's get real now. And I thought, well, that's a good sign. If a conservative judge on the Court of Appeals is saying, let's get real, I think that the time is coming now where the court is going to be interested in this. And that's my hope, is that they will take that case, because that case raises the retroactivity challenge through the ex post facto clause. And also there's a due process challenge, which is simply that you really should be given notice and a chance for a hearing to establish that you present no danger to the community before you're ordered to go on the registry, okay? That's in that case that I'm asking the Court of Appeals to hear. That is also in the Court of Special Appeals case. The other 2 challenges I'm making in the Court of Special Appeals case is that it is an unlawful bill of attainder, which is kind of a clever, I think I'm clever, but it's kind of clever use of the constitutional provision dealing with bills of attainder that I won't go into because it's very boring. But I think it's an interesting argument, and I think that when it is addressed not in a disingenuous fashion, which I'm hoping the court won't be disingenuous, it's a good argument. It's a solid argument for why these registry laws are bad. And and I mentioned the due process. The other argument I'm making, there is a case in Maryland, in both of these, in the Court of Appeals and Special Appeals cases. There is a case in Maryland called Young v. State, which was in 2001 when the laws, were really becoming popular, where it was challenged. The registry law was challenged on the basis of, ex post facto. And the court in that case, which was the Court of Appeals, the highest court, said no, that it's just a regulation. It's not punitive. Well, 2 things have happened since then. The court has changed. The members of the court have changed significantly. And secondly, and more importantly, in that case, what the court said as to why it was not punishment was because there were very few restrictions at the time. There were it was much more limited dissemination of the information, which to me was sort of a key for saying now it's different. We have crossed that line of being just a regulation because it is now disseminated to everybody in the world. It is also far more restrictive than it was in 2001. So the court's case in Young isn't important anymore because it dealt with laws that are far different than they are right now, and that it is, in fact, punitive. So that's one of the other arguments I'm making, that we are now at the point of punitive statutes. I'm hopeful. I think probably in your lives you haven't felt very hopeful for a while. And I can only imagine what it must be like. And I only know from what folks have told me. But again, I'm appalled by it. And I think that the Court of Appeals may think that the time has come to put a stop to this marching forward with these laws and constantly adding new offenses, constantly adding new restrictions. And so my hope is that in 3 weeks I will get the nod from the court that says, yeah, bring it up here. And even if they don't take that case, the Court of Special Appeals has to hear the other one. And so they'll have to deal with it. And I was in the Court of Special Appeals, again, several months ago, where a person was arguing a registry argument before my case, which didn't deal with the registry. So I got to watch her argue the case. And she's a lovely woman and a good lawyer, but she didn't argue it the way I would have argued it. But even still, there are 3 judges that heard that case. One was clearly outraged and said, on the record, he said, this is unbelievable, because she was saying he can't hold a job, he can't rent an apartment. Every time he rents, they come back later and chuck him out. And she just went through this man's life as it exists on the registry. And the one judge said, this has just gone too far. And I was like, wow, he gets it. Somebody gets it. So my point in saying all of this to you about these judges is that I think we're at a point now in the cases where we might get the ear of judges, which is really, besides the legislature, which isn't very hopeful, is the only way you're going to make any dent in these laws is through the court. Now, and it's going to have to be the appellate courts, because my dealings with the trial judges across the state has not always been very pleasant. But they are not willing. They don't want to step out on that limb and say, no, he doesn't have to register, or no, this is punitive. They're afraid. They're just afraid to do that because they have to answer to their community. It'll be in the newspaper, all of that. So the trial judges aren't going to do it. They just aren't. So it's got to be at the appellate level. And they are further removed, obviously, from any specific community. And they are tenured until they're 70 on the bench. Unless they misbehave, they can't get knocked off the court. So they are immune, pretty much, to those political concerns. If they think it's wrong, they'll say it's wrong, and withstand whatever gets put in the paper. So that's where I think we have the best hope, is in these 2 cases, because these raise all the arguments that I think have a chance at making some, hopefully, changes in the laws as they exist now. And what I'll be happy to do is I will email Brenda the actual names of the cases, which are pseudonyms, but I'll give you the number, when it's going to be argued, so that you can continue to follow it if you want. And if they grant mine in the Court of Appeals, I will let you know. And the neat thing is that if the Court of Appeals grants it and hears argument, that's 7 judges on that court. You can watch the argument online. You could certainly go down to the court if you want when the argument comes up, but it might be a little boring. Whereas if you watch it on video, you can turn it on and off. But on their website, you can watch the argument. And it's very interesting because sometimes you can tell or be able to forecast what the outcome's going to be based on the questions the judges ask. You know, if they're not asking me anything, that always makes me nervous, because that means they've already made up their mind and I'm not here to convince anybody. But in that court, that's not usually the way it works. They have lots of questions. But it's interesting to see the questions they ask of the state. And that gives you a sort of you know, you can forecast sometimes what they're going to do. And even you can figure out which judges are on your side based on the kinds of questions or comments they make. So I will be happy to do that and let you all know, so that if I get the chance to be up there, you can watch it, follow it, and hopefully we'll make some changes in these laws. But I want you to know that there are other lawyers out there, obviously, that are working on behalf of clients on the registry. But most of them, when they get those clients, call me to find out what the argument should be, because they know that I have these cases, and I have a lot of them. I want you to know how strongly opposed to these laws I am. I am, and they don't affect me or anybody in my family personally, but I am just so outraged that they think this is doing something good when I see what it's really doing. And I want you to know that I will fight as hard as I can and in any way I can. And I have told Brenda that whatever I can do, let me know. But don't spend your money on lawyers yet. Because if we win these cases, you all are going to be affected by it. Because what it means is the court will say the retroactivity portion in the 2010 law is unconstitutional. So it will affect everybody. So I'll take any questions anybody has. That's really, I just wanted to update you. Yes, sir.
A couple things strike me. Number one, this outrageous idea that it's not punishment. I think we need to find out exactly what the definition of punishment is, and then establish and document among the community of people that are affected by these laws that it is in fact punishment.
Uh-huh.
I mean,
I think actually that's a great idea.
But we need to find out exactly what their idea of punishment. I wouldn't disregard the whole punishment thing, because if the restriction thing doesn't work out, you go back and revisit the punishment thing.
Right.
I mean, there's two things there, and I think go from both 150%. And if one doesn't work, because they might be prepared, they know that you're coming at them with a restriction thing, and then say, okay, well, what's the definition of punishment, and then document, through testimony or whatever.
At the appellate level, you can't put in evidence and you can't call witnesses. It's purely, I get 30 minutes to stand up there and be harassed by the judges and try to convince them I'm right. Then I sit down, the state gets up, gets 30 minutes, and then we leave. Because their opinions have to be in writing. And so they'll come out a couple months later, maybe.
Well, I'm just tossing out days, and I'm just saying, if there's some area that you need help on, I'll be glad to do that. So.
Well, what I was
and I have your contact information, because I was following the Alvarez case, and I never did find out. Is that one of the ones that's still ongoing?
I think it is, yeah.
Yeah, because that's the one that I was extreme, because that applies to my situation exactly. So I guarantee, whatever you need from me, you got it.
Well, what I was thinking might be helpful, actually, is I get written sort of testimonials, if you will, that I would put in what is called the record extract at the appeals level. That it's not, and I would say this is what you're saying is not punishment. I can't introduce evidence, but I can put it in my record extract. And that's part of the argument as well, is that what you have to look at, and the law does define what punishment is in the terms in these cases, and it's like a 4-factor test. It lays out these factors that, if, for instance, is the law in the criminal code or the civil code? Well, we all know it's in the criminal code, but they say, well, that's not the only factor. Then the other is the intent of the legislature. Was it intended to be punishment? And they always say, no, it's not intended to be punishment. The legislature means it just as a method of tracking people and making the community safer. And there are 4 others that, off the top of my head, or 2 others that I can't recall, but and you go through each of those, in my argument I do, go through each of those and say why it is punishment. So, you know, there is a definition that they have to follow. And the other one is, you know, if you do something wrong, you're facing 3 years. So
Sure.
that's part of the punishment argument. Willful ignorance is what I call it.
Okay.
Because they want the laws, and they want to make them retroactive, and for 2 reasons. They want to make them retroactive. The main reason is to comply with the federal law, so I get the federal funds in the state. So, and the federal law is ridiculous. I mean, so they track what the feds do. So they get the federal funds, and, you know, and it's retroactive. So the only way they can make it retroactive lawfully is to say it's not punitive. And one of the other things they say is there's no stigma attached. Yeah. No stigma.
I just want to try and understand what you said. And one of the things that you said about not everybody falls under that, what's that? Retroactive law.
Right.
Were you saying that you had another case that for people who don't fall under that retroactive law?
Well, some of the due process argument would apply to folks that were on it before the retroactivity law was passed. And so would the punishment argument, which is that, you know, this isn't just a regulation. This is punitive now, that we've crossed that line. So those other constitutional arguments would apply to those that were not necessarily brought on retroactively.
I know you're not a seer or anything, but do you foresee the abolishment of a registry?
No.
Okay.
I mean, I'll just be honest with you.
Okay.
No. I don't.
Oh, do you see the abolishment of a registry that's public?
That, I don't know, but probably not. I mean, you know, I'm just basing this on the legislators that I know down there, and I just don't see it. Because, you know, their constituents, anybody that hears the word sex offender, whether it's, you know, a college kid who got drunk one night and had sex with somebody he thought was, you know, 18. I have one of those clients too. And the next morning she claimed rape, and now he's on the registry. You know, but so sex offender covers lots of different, you know, crimes and situations, a lot of which have nothing to do with being a pedophile, have nothing to do with being a danger to the community. And so, but the problem is you hear those 2 words, sex offender, and everybody just goes crazy because all they think of are pedophiles and dangerous people. And so playing to your constituents or hoping to get reelected and your constituents are saying sex offenders this, sex offenders that, I just don't see it likely that they'll do away with the registry or make it private.
People who are on the registry, say for 25 years, what do you think of the likelihood of someone going to court after 10 years maybe and getting their name off the registry?
I think that's possible. I do. I think that, assuming that in those 10 years, you know, everything, you know, went well and your lives back on track and whatnot, I think that even the trial courts would be willing at that time to take you off the registry. Which, by the way, I wanted to mention, I forgot. You know, some cases should be going into court on different issues and dealing with the registry instead, because these appeals won't affect their situation. But the only way to do it, it's not related to your criminal case. The only way you can get back into court is on what's called a complaint for declaratory judgment, which is a civil proceeding. You know, but I just wanted to let you know that if you ever go to a lawyer, ask, you know, about getting back into court, make sure that that's the way it goes, because any other way to get into court, they'll throw it out, so you waste your time. So, a complaint for declaratory judgment, which is essentially asking the court to declare the rights of the parties, you and the state. Is it your right to get off the registry?
Okay, hi, I'm Jay.
Hi.
I appreciate you being here.
Thank you.
If I'm correct, the arguments that you're presenting, which have reached the highest level in other states, has been successful. Is that correct?
In, I think it's 7 states that I'm aware of, actually.
Okay.
Massachusetts, Alaska, Kentucky. I can't remember them all.
Is that an argument you can use, or since
Oh,
you're
yeah.
in? Yeah.
It's in my brief, yeah.
Okay. The other thing is the lawyer that I've been dealing with said that the thing that he sees as most arguable is the restraint, the inability for me to travel
Yeah.
outside the state. Could you speak to that?
Yeah, and that's part of the argument on, that I'm making as well. It's sort of in on the punishment angle. Yeah, it's a restraint on your travel, which you have a constitutional right to do. Now, I don't break it out as a separate issue, and that's because these 2 clients in particular are not, they don't look to travel, and they're not concerned about that, aspect. But yeah, I think that's a plausible and possibly successful argument as well. I don't know if other states have addressed that specific issue. I'm not sure, because I'm not aware of any case where that was like the only challenge. But it is a viable challenge.
Next is, can we oppose the tier system that Maryland has come up with, since they're now calling 80% of the people who are sex offenders, if I'm correct, 80% are in Tier 3, which means they're in the predator level.
The way the appeals are working, to my understanding, is, yeah, you are appealing to the registry office to say you made a mistake. That's the purpose of the appeals right now. So it's for instance, a lot of people who had simple porn possession, it seems like everybody ended up with possession and distribution, which bumped them up to Tier 2. So when the law first took effect, a whole lot of people found themselves in 25-year when they thought they were going to be on 10 or 15. A lot of those got fixed because there was a computer glitch. But to just simply say, you've been correctly assigned to Tier 2 or Tier 3, and you think that, you've had a stellar record and therefore you should be taken off, that's not a part of the appeal process that we have in place right now.
I was told that many states do not go along with this, lifetime registry, and if I moved to another state, that it would go back to my original sentence, which was 10 years of registration. Do you know if that's true?
If a state that you want to go to has a different tier, crimes and tiers, yeah, you'll be a part of their registry. And so whatever their state requires is what would apply to you.
So they go by what your original sentence was?
No, they go by the name of the crime, whatever the crime is. That's the same way if somebody moves into Maryland from another state and they were convicted in that state of, because everybody calls their crime something different. Whatever they called their offense, and we don't have the exact same name of an offense, then the folks at the registry, I know the woman who does it, her job is to find what crime it is most like in Maryland, and she decides unilaterally where it fits, and then gets put in that tier.
If there's a positive outcome to these 2 cases, can Maryland or the Attorney General's office appeal it to be retried?
Well, if I prevail in the Court of Special Appeals, the state can then ask the Court of Appeals, let's call it Maryland Supreme Court, okay? Because they're the only, besides New York, we're the only state in the country that calls our courts that, but let's call it Maryland Supreme Court. If I win in the Court of Special Appeals, the state will most definitely appeal to the Court of Appeals. But the Court of Appeals picks and chooses the cases they want. It's not an automatic right. if I lose in the Court of Special Appeals, I can tell you right now that I will file a petition with the court, okay? If I lose in the Court of Appeals case, the next, step for them is to go to the U.S. Supreme Court. And I think there's a good possibility they would do that. I really do. And of course, here's a caveat to that, though, which is sort of why I raised it the way I did. If I win on the Maryland constitutional issue, the restriction versus, then they can't appeal to the Supreme Court. And the reason for that is because that's based on a state law. And the only cases the U.S. Supreme Court hears are cases based on federal constitutional law. Okay, so there's no federal question involved if they decided as I'd like them to. So it could be the last step, or the last word, I should say, or depending on how the court rules, the state may be able to take it to the Supreme Court.
Second question is, if special appeals or the appellate court rules not in your favor, do they have to give you an item-specific breakdown of why they're not ruling?
Yes.
And the reason I ask that is because if there's another similar case, but with slight differences, can that be used to possibly pursue that in special appeals or appellate to, push that for a favorable outcome?
Yes. When the Court of Special Appeals issues its opinion, the same in the Court of Appeals if they take it, they must address every issue that was raised and say why they ruled one way or the other. So if their reason does not apply to your case, your situation, then you can still move forward with your case and appeal it because it's different. But if they do it on a very broad, general opinion, then the likelihood of you being treated any differently on appeal would be zero, and you would waste your money.
What's the history on cases where someone has violated the sex offender registry laws and gone to court? Were they given 3 years? What was the judge's opinion on that, and how many cases have gone through that way?
I personally know of 4 in different jurisdictions around the state that were charged with violating and were given 3 years. But several of those I appealed and won, so they got that wiped out. But yeah, I think the courts are more than willing to, if you violate, they're more than willing to give you the extra time.
So then, but that's not punishment, right?
Right. I mean, it's a huge, what do you call it? It's just,
Vicious cycle.
it is. It is. It's just like, you can never get out of it, But as long as they say it's not punishment, it's just round and round you go. So.
Not everybody owns their own business and has some spare cash, but that is an important thing to keep in mind when you're being harassed. If you sit back and just take it, it's going to get worse. And we've all seen that enough just with the laws. So do your homework, know what the law is and what your rights are. And if they start telling you stuff that you know isn't true and trying to push where you shouldn't be pushed, tell them no. Tell them you'll go talk to your lawyer, even if you don't have one. Just say you're going to go talk to your lawyer. You've got to push back, because as long as they know they can stomp all over you, they're going to stomp all over you.
Feel free to email me if you have questions. I just got a guy from Wicomico County off the registry who's been on it for 10 years, who never should have been on it at all. And I didn't even give him a fee agreement because it just pissed me off so much, And so, now I'm not saying I'll do everything pro bono, but I'm cheap, and sometimes I get outraged enough that I'll just do it, Yeah, well, yeah. Yes. Yeah, do you want it now? Okay, it's N as in Nancy, S as in Suzanne, and then my last name, forster@gmail.com. And I have some cards that I'll leave with Brenda too, and I'm not trying to get business. I mean, I honestly, I'm not here for that reason at all. But I'm happy to answer questions or, you know, point you in the right direction or tell you what I think your chances are or whatever. And if I'm outraged enough, I'll just do it for you, so.
Again, since my crime was so old, there was not even that particular law on the book or that particular title.
Yeah.
And I think 3 times they've looked at my crime and decide, well, that it's most like this crime today. Can you appeal that? The way that they decide how your old crime fits the new crime, because that's what continues to
I know.
keep me being punished more.
Yeah, no, you can't appeal it. And, you know, which is one of the things actually that I put into the cert petition, although it has nothing to do with the case, but just as a point of reference so the court knows that there's this woman, and she's perfectly nice, you know, Elizabeth Bartholomew, very lovely woman. She's not a lawyer, and she's the one who makes all the decisions. And I asked her one day, I said, well, wait a minute, you know, where do I appeal that to? And she said, you know, nobody. She said, this is it. And so the only way you can is through a declaratory judgment action, is to file a complaint in court, in circuit court, and say, I don't belong on this registry for this length of time or at all, for whatever the reason may be. That it's been classified wrongly as this type of a crime, because it isn't this type of a crime. So, you know, it's in the court that you have to do it, because there's no, in the public safety world.
You can't appeal it, but you'd have to appeal it in the court.
Correct. And it's an original action as a complaint for declaratory judgment at the circuit court level. So it's not really an appeal. It's an action that you take.
And one last question. I travel extensively, used to travel extensively. I have just quit traveling since, you know, the 7-day restriction.
Right.
But I will let people know, if you do travel and you're using a passport, expect to be pulled out when you not when you leave the country, when you come back to the country. Your passport has been and will be flagged, and you will be taken to a separate area and undergo, you know, major scrutiny and all kinds of things. So just expect that. And is that because being on a state registry automatically goes to the federal, so that it's your passport is flagged?
Correct. And anytime you leave the country, even, you know, lawfully, they alert Interpol. There are times when a statute can be made retroactive lawfully without offending the Constitution. But the times that it can't is when it changes your punishment or changes the crime that you were convicted of to make it worse. That's when they can't do that. If I win in the Court of Appeals, the opinion doesn't become final. They don't issue a mandate, which makes it an official decision for 30 days after they issued the opinion. So in those 30 days, the state would probably start removing people, so that by the time it becomes a final decision, hopefully they will have made great headway. So there is time. The 30 days that is in between the issuance of the opinion and what's called the mandate that makes it official is generally for the court to make any changes to the opinion, like if there are typos or they want to take a line out or put another line in. It's not to change the entire opinion, but so they give themselves that 30-day sort of grace period before it becomes final. Like I said, in 3 weeks, I'll know whether the Court of Appeals takes that case. And if they take it, that means that it will be argued in July, and then there's no time frame for that court to issue an opinion, and depending on who the judge is that writes it, that it ranges from 2 months to 3 years. But that judge, I think he's taken a lot of grief because they've been writing articles in the paper about it. So I don't think it will take that long. But my guess is that if that case goes through, we will probably get the court's opinion by the end of the year. Now, the other case is much further along. I'm arguing that in April or May, I just can't remember. Let's say it's May. That opinion will probably come out in the summer. So that's the time frame you're looking at.
Obviously, when you win,
Okay.
it's going to be, it's going to have widespread ramifications to this whole system. Is that something that the judges take into appeal indirectly in their heads, or is that absolutely not a part of their decision?
I think that's a really good question, and I'll answer it with an example for you, talking about the Court of Appeals. And the answer is no, because they just had a case come out. In a nutshell, it was a lawsuit against the Office of the Public Defender because they were saying that the office had to provide lawyers to indigent people who were arrested, and even before they got charged or anything, and when they go before a commissioner, which happens around the clock. People don't get arrested at certain times of the day. It's 24/7. And the public defender's office cannot possibly meet that requirement because they don't have enough lawyers, number one, or resources and money. So that went up to the Court of Appeals, and knowing that it would require, I think they said, another almost $30 million for the Office of the Public Defender to comply, the court issued an opinion and said, well, comply. So the fact that they knew that it's going to cost a ton of money and they got to hire a whole slew of lawyers and that they couldn't possibly do it, they still came out and said, you have to do it. So no, that sort of thing does not enter into their mind. If they are convinced that something is unconstitutional or, is violative of a statute, they will say it no matter what. So because, like I said, and that's the beauty sort of having those judges tenured until they're 70. They don't have to account to any, except the judicial disabilities if they've done something improper, of course. But they don't have to account to any political segment or constituency. And so politics doesn't enter into it.